and then we page over to page 8, question 522. The following statements concerning the rights and preferences of the petitioner and respondents in a foreclosure. Which of the following statements is false? And the answer for 522 is number 4. Where the value of the property being foreclosed exceeds the total amount of the mortgages, both the petitioner and the respondents will justify or will desire a judicial sale of the property. No, so this one is false. Okay, about the rights and preferences of the petitioner and respondents in a foreclosure. If your property's value is more than the mortgage values, you can't force a sale, a judicial sale. No, so that's false, and that's our answer. These other things are true. 1, if the value of the property is less than the amount of the mortgage debt owed to the petitioner, the mortgagor would want the property to be foreclosed, while the petitioner would want the property to be sold in a judicial manner. That's true. 2, where the value of the property exceeds the total amount of mortgages, the respondents would want a judicial sale, but the petitioner would prefer the property to be foreclosed. And 3, where the court orders a judicial sale, the petitioner may make an offer, and if the court approves the offer, the petitioner will become the registered owner and still be able to sue the mortgagor for any shortfall between the sales price and the mortgage debt. It's also true. But our answer is here, number 4. Where the value of the property being foreclosed exceeds the total amount of the mortgages, both the petitioner and the respondents will desire a judicial sale of the property. No. No. Okay. Both petitioner and respondents want a judicial sale. No. Because we just saw in 2 here that says the respondents want the judicial sale, but not the petitioner. Petitioner doesn't want a judicial sale. Petitioner wants a foreclosure. 542, which of the following statements regarding mortgages is false? And the answer is 4. Once the mortgage terms have been agreed to by the mortgagor and the mortgagee, the mortgagee is bound to advance the total amount of the funds when requested by the borrower, regardless of the terms of the mortgage. No. You can't ask for the total amount of funds. That's fucked up. So that's false. But these other things are true. 1, a mortgagee may require the addition of a guarantor to provide a separate personal covenant as a third party in addition to the borrower's personal covenant to pay. Yep, they might need a third party. Or 2, where the property secured is a condo, a mortgagee may require the borrower to grant to the mortgagee the right to vote at meetings of the strata corporation on various matters affecting the security of the mortgage. So yeah. 3, although a number of remedies is usually available to a mortgagee in the event of borrower default, the lender usually has complete discretion in deciding the most suitable remedy to use in the circumstances. Yeah. So basically, the lender, they can pick and choose their remedy. So those are all true. But the false thing is that when the mortgagor or mortgagee have agreed on terms of the mortgage, mortgagee is bound to advance the total amount of funds when requested by the borrower, regardless of the terms of the mortgage. No, you're not bound to advance the total amount. That seems kind of weird, but whatever. It is what it is. Said David. 548. Which of the following clauses contained in the mortgage would constitute a clog on the equity of redemption and therefore be void? 548. The answer is 2. Option to purchase clause. So this option to purchase clause, it would constitute a clog on the equity of redemption and therefore be, but you can't do an option to purchase. No. All right. 583. A mortgage of the mortgagor's equity of redemption is called 583-2, an equitable mortgage. If you do a mortgage of the mortgagor's equity of redemption, it's 2, an equitable mortgage. Page 9, 584. The court order usually obtained first in a foreclosure action is a number 1 order nisi. So the nisi gets you your foreclosure, all right? 686. Which of the following is not a mortgagor covenant? And the answer is 3. To convey the property to the mortgagee at its option in exchange for an amount equal to current market value. This is not a mortgagor covenant. 3. To convey the property to the mortgagee at its option in exchange for an amount equal to current market value. So that's not a mortgagor covenant. But 1 is pay all taxes on the land and on the improvements. 2, keep the premises in a reasonable state of repair. 4, pay the debt accrued interest according to the agreed upon schedule. Those are all mortgagor covenant items, but not 3, to convey the property to the mortgagee at its option in exchange for an amount equal to current market value. 706, which of the following statements about federal legislation governing mortgage interest rates is true? And the answer is 4. The Interest Act provides that if a mortgage agreement does not specify the rate of interest chargeable, the rate allowed by law is 5%. So get that. This is very important here. If you don't fix a rate, the Interest Act says it's 5%. You got that? Don't forget it, buddy. 756. 756, and the answer is 3. A mortgage is a conveyance of land as a security for a loan and carries with it the mortgagor's equitable right to redeem the security on payment of the debt even after default. So the answer is for 556 is 3. A mortgage is a conveyance of land as a security for a loan and carries with it the mortgagor's equitable right to redeem the security on payment of the debt even after default. 772 on page 10. Under the Land Title Act in BC, a mortgage is registered on the title as a charge. Number 1. Under the Land Title Act in BC, a mortgage is registered on the title as number 1, a charge. 787, which of the following is not a common covenant of the borrower? And number 4. Provision to waive the rescission rights under the Mortgage Brokers Act. Okay, that is not a common covenant of a borrower. No, it's not a borrower's common covenant for provision to waive the rescission rights under the Mortgage Brokers Act. You can't waive rescission rights. Okay, but these are common covenants. 1, provision to pay all property taxes. 2, provision to keep the property well maintained. And 3, provision to insure the property to replacement value or such lesser amount as the mortgagee determines. Okay? You got that? Alrighty then. So we're moving right along. 831. A collateral advantage given with the mortgage will be declared unenforceable by the courts if 831. 4. Any of the above applies. And what are these things which an unenforceable collateral damage? Number 1, if it's unfair or oppressive. Number 2, it is the nature of a penalty. Or 3, it is unduly restrictive. So all those things are true about collateral damage. It'll be unenforceable. If it's unfair, it's oppressive. If it's a nature of a penalty or unduly restrictive. 835. Which of the following are examples of equitable mortgages? And the answer is 4, all of the above. So we got A, B, and C. A, B, C, D. A, a mortgage, so this is equitable mortgage. A mortgage disguised as a transfer of land where the sale price is below the market value. B, a mortgage which, for procedural reasons only, is unregisterable in the land title office. C, an agreement to execute a mortgage in the future under which the borrower has already received the principal amount. D, a mortgage registered second in priority to another mortgage. So all these are true. Page 11, 861, a contract between the seller of real estate and the buyer, whereby the vendor agrees to sell their interest in that land to the buyer for a specified price, payable in installments, and upon payment of the price in full, to transfer title to the buyer. It is called 861.3, an agreement for sale. An agreement for sale is that contract between the seller and buyer, basically sell their house. Page 12. Oh, and I just want to explain a little more about 861. The answer, agreement for sale. This statement is an agreement for sale. The usual form is that the buyer agrees to pay monthly payments of principal and interest, and in exchange for the promise of payments, the seller grants possession of the property to the buyer, with title transferring upon final payment. An equitable mortgage generally refers to a subsequently registered mortgage after the first legal mortgage, charging the borrower's equity of redemption. Under the agreement for sale, the seller remains on title as registered owner, whereas with an equitable mortgage, the borrower remains on title and the mortgage is registered as a charge. An agreement of purchase and sale is generally regarded as the contract, usually standard form, between the buyer and seller. A disguised form of mortgage is usually found when the main purpose of a sale of land was to offer land as security for a loan. 8A3. When an order absolute of foreclosure is obtained by a petitioner who is in the position of second mortgagee, that's kind of dangerous. 3. Only A, B, and D are true. A, that mortgagee can no longer exercise its right to sue the borrower on his or her personal covenant. And we also got A, B, and D. B, the order forecloses the registered owner's interest in the mortgaged land and permits the petitioner to transfer title into his or her own name. And D, the petitioner may sell the property after taking title to it and does not have to account to the borrower for any profit which might be realized in excess of the mortgage debt. So A, B, and D, that's number 3. That's an order absolute of foreclosure. A, mortgagor can no longer exercise his right to sue the borrower on his or her personal covenant because they're in second place. B, the order forecloses the registered owner's interest in the mortgaged land and permits the petitioner to transfer title into his or her own name. And D, the petitioner may sell the property after taking title to it. I think it's the first mortgage bank or whatever, and does not have to account to the borrower for any profit which might exceed in excess to the mortgage debt. All right. Interesting. 934. ABC Loan Company, ABC, has agreed to lend $2 million to Devco Limited in exchange for a registered first mortgage against Devco's current residential construction project. The loan's to be paid out in 4 equal installments over a 5-month period, but all payments are at the discretion of ABC under the advances clause in the mortgage. The first installment has been paid, and it is now time to pay out the second installment. ABC has discovered that a builder's lien has been filed against Devco's property. You correctly advise ABC to get their act together. 2. If the second installment is advanced to Devco, the lien claimant will have priority over this and any other advances made under the mortgage after the date of registration of the lien. So my answer for 934 is 2. ABC company, you got to say that number 2. If the second installment is advanced to Devco, the lien claimant will have priority over this and any other advances made under the mortgage after the date of registration of the lien. So you got to let them know that. 942, which is on page, let me see here. Oh, you know what? I screwed up. Did I screw up? 861. I think I screwed up in 861. Let me go back to that. No, I already did that. Agreement for sale. Agreement for sale, yeah, I did it. Okay. Page 13, 942. Which of the following statements are concerning mortgages is false? And the answer is 1, a mortgage is a loan. Okay? Mortgage is not a loan. But these other things are true. A mortgage is an interest in land created by contract. Yes, it is an interest in land. 3, the relationship of the parties to a mortgage is that of debtor and creditor. Yes. Relationship of the parties to a mortgage is that of debtor and creditor. Yes. And 4, at common law, a first mortgage transferred legal title to the mortgagee. Yeah. First mortgage transferred legal title to the mortgagee. That was under common law. 953. In a mortgage transaction, the mortgagor is the mortgagor. And the answer for 953 is number 4. All of the above. 1, the borrower. 2, the fee simple owner of the mortgage property. And 3, the holder of an equitable right to redeem the mortgage property. All are true. 961. Which of the following statements regarding the effect of registration of a mortgage in a BC Land Title Office, LTO, is true? And the answer is 3. Registration of a mortgage raises only a rebuttal prescription that the mortgage is valid. A registered mortgage is not guaranteed under the BC Land Registration System. So this is true in regards to the effective registration of a mortgage in the BC Land Title Office 333. Registration of a mortgage raises only a rebuttal presumption that a mortgage is valid. A registered mortgage is not guaranteed under the BC Land Registration System. My goodness. 969. In the absence of a priority agreement, which of the following would not be named as respondents in a foreclosure action? So who's not going to be named in the foreclosure proceedings? And the answer is 4, priority mortgage lenders. They're not going to be named as respondents in a foreclosure. Prior, not priority. Prior mortgage lenders. So those guys are part of the history books. They are not named as a respondent when there's foreclosure things happening. But number 1, the borrower is mentioned. Number 2, a buyer from the borrower under the agreement to sale is also mentioned, and the guarantor is also mentioned, but not prior mortgage lenders. That's it. That is Chapter 15, Lesson 11, Intro to Mortgage Law. Stay tuned for Chapter 16.